On March 7, 2020, 23-year-old Keelin Hawkins was arrested and charged in the Harris County criminal courts with driving while intoxicated. That same day, she was released on what's known as a general order bond under Harris County Local Rule 9. This rule requires that, with a few exceptions for certain carve-out categories, all misdemeanor arrestees must be granted an unsecured personal bond and promptly released without the need for a judge's approval. In other words, for most misdemeanor arrests in the county, release happens automatically, and the sheriff is instructed to let the person go without collecting any upfront payment or holding a separate bond hearing. Harris County's general order bond system is distinctive. It was created as part of a November 21, 2019 consent decree, the result of the 2016 class action lawsuit O'Donnell v. Harris County, which alleged that the county's previous misdemeanor bail system was unconstitutional. The consent decree ushered in a wave of bail reform, including the automatic release provision through general order bonds. After Ms. Hawkins was released, her arraignment was scheduled for March 13, 2025, in the courtroom of Judge David Flecher. Judge Fletcher's role was to determine whether probable cause existed to support the DWI charge and to revisit the issue of bail. Ms. Hawkins' defense attorney of record was Greg Holton, but on that day, it was his colleague, Aaron White, who appeared on her behalf. Judge Fletcher. Good morning, Ms. Hawkins.
Good morning, Ms. Hawkins. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On March 6, 2025, at approximately 10:29 p.m., the officer observed a vehicle driving with expired registration as of March 2021. A traffic stop was initiated. However, the vehicle continued to travel down the feeder road until it turned and pulled onto the wrong side of a two-way road and parked facing northbound in the southbound side of the roadway. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed the defendant to have bloodshot eyes, droopy eyelids, and a strong odor of an alcoholic beverage. The defendant admitted to drinking 1.5 alcoholic beverages, and the defendant stated she was buzzed but not drunk. An inventory search of the vehicle was conducted, and the officer found a large plastic cup that was 1/4 full of alcoholic beverage that smelled of tequila in the center console cup holder. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused to provide a specimen. A blood search warrant was signed and executed.
Are you telling me that she has alcohol in the car while she's driving?
It's just she had a cup of alcohol.
Ms. Hawkins, I'm going to find that there's sufficient probable cause to go forward with your case. I am now placing several conditions on your bond. If I find that you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds, ma'am. You're not allowed to drive. I'm taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. This is an affidavit that you're going to promise to me that you're not going to drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, ma'am.
Judge, is that standard for driving?
She has alcohol in the car while she's driving. And so I would presume that it's elementary that you're not to have alcohol in the car while you're driving. It scares me, and I just don't want her driving for now.
After finding probable cause for the DWI charge, Judge Fletcher imposed specific conditions on Ms. Hawkins' bond, ordering her not to consume alcohol and not to drive at all. This went beyond what the prosecution had requested. In a written motion, prosecutors only asked that Ms. Hawkins be required to install an ignition interlock device, or IID, a breathalyzer system installed in a vehicle that prevents it from starting if alcohol is detected on the driver's breath. Under Article 17.441 of the Texas Code of Criminal Procedure, judges must require an IID for defendants charged with repeat DWIs or aggravated DWI offenses, such as DWI with a child passenger. However, since Ms. Hawkins was a first-time DWI defendant, that article did not make an IID mandatory in her case. Still, under Article 17.40, Texas judges have broad authority to impose any reasonable condition of bond that relates to community safety. Importantly, judges cannot use bond conditions as a form of punishment before conviction. As the 14th District Court of Appeals in Houston explained in the 2022 case of Ex parte Bucks, appellate courts review bond conditions under what's known as an abuse of discretion standard. In other words, a trial court's ruling will stand so long as it falls within the zone of reasonable disagreement. Here, given the allegations that Ms. Hawkins had been driving while intoxicated and had an open container of alcohol in her vehicle, it's highly likely that a reviewing court would find Judge Fletcher's restrictions prohibiting her from drinking alcohol and from driving to be reasonably related to public safety and therefore not an abuse of discretion.
Understood. But
We can approach at a later date, but
I'm concerned because for her employment, she can't get to and from work, and we can't get an occupational license or something like this. It's a condition of the court. I don't think we have any opposition to putting an interlock in the vehicle so that she's not able to drink and then drive. But it just seems like no driving at all seems a bit harsh for a first offense. We don't even know what the blood is at this point.
get it? But she has alcohol allegedly in the car while she's driving. One would presume that that's a humongous no-no, you know? And I want her to appreciate the privilege it is to drive. It's not a right. It's not a right. It's an absolute privilege.
Judge, if I may, what would be the conditions under which she's able to come back and get permission from the court? At what time frame?
I need to know that she understands and appreciates the privilege, you know, be proactive. It's not forever, Aaron, you know, but I want her to understand that it's a privilege, it's not a right, and it's something that people should take very seriously. I don't want you to talk here now in front of him. You know, you guys at a later date can come back. I'm always all ears. Like, it's not
For
absolute.
Greg's purposes, since he's going to be the one representing her, what is a later date? I mean, is there something we can do? Because, you know, if it's something that you'd like her to do while on bond to make sure that she's, you know, addressing the issue. I mean,
Be creative, be proactive. I want to know that she appreciates it, and I'm all ears, you know? But it's something that I've seen more and more, you know, where there's alcohol in the car, and I would presume that you would know, especially at this age, that, you know.
well, to be fair, Judge, the allegation is that she violated the law. The presumption is that you would know not to violate the law, period. I personally don't think that the fact that there is possible alcohol in the car, I don't think it's been tested, but it just seems like no driving at all seems like a harsh penalty for someone who's never been arrested before, no criminal history. These are allegations. There's a blood draw pending. According to the dim summary, she had 1.5 drinks. It's certainly possible her alcohol level comes back below the legal limit.
Mr. White requested that Ms. Hawkins be granted limited driving privileges, allowing her to drive to and from work, but Judge Fletcher decided to maintain the complete driving restriction for the time being. It's important to understand that a bond restriction on driving is not the same as a driver's license suspension under Texas's administrative license revocation process. These are two separate systems operating under different authorities. Because Ms. Hawkins' blood test results had not yet been processed at the time of the hearing, her license was likely still valid and not yet suspended under administrative law. Still, under Article 17.40 of the Texas Code of Criminal Procedure, judges have broad discretion to impose any reasonable bond conditions connected to public safety. That discretion gives a judge the authority not only to completely restrict driving, but also to allow limited driving privileges, such as commuting to and from work, while still prohibiting non-essential travel. If Ms. Hawkins' blood results later showed a blood alcohol concentration of 0.08 or higher, the Texas Department of Public Safety, DPS, would be required to suspend her driver's license under Section 524.012 of the Texas Transportation Code. That section mandates the automatic suspension of a driver's license whenever a person is found to have operated a vehicle with a BAC above the legal limit. Even if Judge Flecher later decided to lift the driving ban or grant restricted driving rights under her bond, Ms. Hawkins still could not legally drive once her license was suspended, unless she obtained an occupational driver's license under Section 521.242 of the Transportation Code. An occupational license would allow her to drive solely for essential purposes, such as work, school, or necessary household duties, even while her regular license remained suspended.
And if that takes 90 days to get those lab results and come back and get this taken care of, she's not driving for 90 days.
I'm not saying that long, Aaron. I just want some kind of proactivity that I know that she appreciates. Come back and,
And this is
Hey,
for
you
purposes, so I can convey this to better. What's proactivity to the court?
just be creative.
Okay.
Be creative. And, several weeks, come back and we can talk. But it's a privilege. It's not a right. And it's something that we take very seriously. Every single day, someone dies from a DWI in our county. Every single day. And we need to ensure that it's taken seriously, I'm not asking for much. And once we know that there's appreciation, then let's talk again.
On April 8th, 2025, Ms. Hawkins' attorney formally filed a motion requesting a hearing to review and possibly modify the existing conditions of her bond. Just 2 days later, on April 10th, 2025, Ms. Hawkins appeared once again before Judge Flecher, marking her second court appearance in connection with the DWI case. This time, she was accompanied by her primary defense counsel of record, Greg Holton, rather than by his colleague who had represented her during the initial arraignment. The purpose of this hearing was to give Mr. Holton the opportunity to address the court directly, present any new circumstances or arguments, and advocate for adjustments to the restrictive bond conditions previously imposed by the judge.
How's it going?
Oh, good. Thank you.
How has it been? Not tough, isn't it?
Yeah.
Sucks. Living in a city as big as Houston without the ability to drive blows. And the only thing that I'm trying to get to you is to understand that it's a privilege. It's not a right. Every single day on our streets, someone is dying from some kind of alcohol-related collision. That's what we're trying to impart to you here, to take it seriously. It's not a joke, and the last thing I want is for something like that to happen here. You understand? All right. I'll take off the restriction. Okay.
Judge,
What does she have now? I want to make sure that she has an interlock for now, just for a limited time.
Judge, if I could speak to that briefly,
Sure.
just to reassure the court that she fully understands the court position. I had her research and write an essay on alcohol-related accidents and fatalities. We can turn that in and take a decision-making course. Her case is a stop for expired registration, no accident. You got the blood this morning, it's a 1-3. She has no criminal history. So I would ask the court that to use this, the research she's done in the 28 days without driving at all, to understand that she gets it. And if we can not have the interlock, as would have been if she didn't have an open container, that we proceed further and let us do the work of getting the discovery forward.
Okay.
I can turn both those in.
I want you to know, I will act to your lawyer, but if I find that you're using alcohol, I'm gonna blow a gasket. I'm really just gonna lose it. Just don't. That's all I'm asking you to do. Do you understand?
Yes.
Okay. I'll take a look at this. I'm gonna acquiesce to you.
Thank you, Judge.
Just don't. Life is too short to spend the next month in a 6x9 box.
During the April 10th hearing, Mr. Holton informed Judge Fletcher that Ms. Hawkins' blood test results had been returned, showing a blood alcohol concentration, BAC, of 0.13, well above the legal limit of 0.08 in Texas. Despite this result, Judge Fletcher exercised his judicial discretion by removing the no driving restriction previously attached to Ms. Hawkins' bond. At Mr. Holton's request, the judge also chose not to impose an ignition interlock device, which is a breathalyzer system often required for individuals charged with DWI offenses. However, since Ms. Hawkins' BAC exceeded the legal threshold, her driver's license was almost certainly subject to administrative suspension by the Texas Department of Public Safety. This means that, even though the judge lifted the bond restriction, she could not lawfully drive unless she either obtained an occupational driver's license, a special court-authorized permit allowing limited driving for work or essential duties, or successfully appealed the suspension during the administrative review process. It's important to note that the administrative license revocation process operates independently from the criminal case. Therefore, the issue of her driver's license was not addressed during this hearing, and its final status remains uncertain. As of the date of this episode's recording, Ms. Hawkins' DWI charge remains pending. What this hearing ultimately illustrates is how Judge Fletcher utilized the broad discretionary authority granted to him under Texas law, balancing public safety and fairness. First, by restricting Ms. Hawkins' driving and alcohol consumption entirely, and later by modifying those conditions despite the state's initial request for an ignition interlock device.
About a month later, Judge Fletcher once again exercised his judicial discretion, this time in a follow-up hearing, to remove the no driving condition from Ms. Hawkins' bond, even choosing not to require an ignition interlock device. Bond conditions serve as judicial tools designed to protect community safety while still allowing defendants to remain out of custody as their cases move through the courts. Now, opinions on Judge Fletcher's initial decision may differ. Some viewers might see the early restrictions as unfair or excessive, especially considering the limited information available at arraignment when the blood alcohol test results weren't yet returned and the contents of the alleged open container remained untested. Others, however, may view those same restrictions as responsible and temporary safeguards, a cautious approach meant to minimize risk while awaiting complete evidence, with the understanding that judges can later revise conditions as new facts come to light. And in this case, that's exactly what happened. Judge Fletcher reassessed the bond terms once additional information became available, demonstrating how the process is designed to adapt rather than remain static. Under Texas law, judges possess broad discretion to impose or lift bond conditions that are reasonably tied to public safety, meaning that the initial driving ban, though it may have felt strict or unfair to Ms. Hawkins, was almost certainly lawful. Let us know in the comments if there's another case or courtroom interaction you'd like us to cover. Thank you for watching, and don't forget to like, subscribe, and share to help us continue fostering a more informed and justice-aware society.